Hello, everyone, and welcome. I'm really super excited about this really timely coffee break in Privacy Kitchen. I'm delighted to have Stine here from Legal Monster, who's a partner, a Privacy Stack partner of Keepable. Stine, would you mind introducing yourself and Legal Monster?
Sure. Thank you so much, Robert, for having me. I'm very excited to be here. So my background is as an attorney from Denmark, 6 years at one of the big law firms, having clients like Google and Netflix and HBO. So privacy and data and tech is kind of like my forte. We're in-house for 6 years, where I headed up legal and compliance at a company called Trustpilot. And from there, I started Legal Monster together with one of my co-founders. And we're kind of like helping companies on a compliance journey with everything that is related to online presence.
Yeah.
And by that, cookies are one of the things that we help companies with, because it's something that everybody knows that they need, don't really understand completely what it actually means and how you should be managing it. On top of that, we help with like capturing the right consents through your privacy policy, making sure you get the right consents, and actually thereby help them to ensure that they're doing the right thing online and are able to build trust with the audience that they're actually going to actually showcase that they're doing the right thing.
Yeah, that's fun, and it's so exciting to be partnering with Legal Monster, and cookies is just one part of what you do, and the whole, it's all sort of driven by this whole consent and respect for the user, and it's also very tailored across the different countries, which I think is really interesting. I think what's really interesting as well is, you know, your solution is super simple to both to implement and to interact with. And I think that's when you say, you know, people are concerned about, do I have the right notice in place? Does it say the right thing? How do I change it? And that usability is really key, which is what we're all about as well, which is why it's great, like minds in privacy. So we're talking about cookies on this one. So, and it's really timely because the e-privacy regulation, a draft e-privacy regulation, has just been adopted at the council stage and going to negotiations. So there's a long way to go on that, but we'll touch on that later. But we had in December a huge fine, 135 million euros from CNIL on Google and Amazon for cookies, really simple mistakes they did. Also, the number of complaints to the UK regulator, the Information Commissioner's Office, has ballooned. I'll just get the stats from 147 in 2007-18 to 2,500 in 2019-20, an increase of over 1,600%. So this makes this very relevant. But Stine, why do we care so much about cookies, and why would a regulator care so much as to take hold of that case of Google and Amazon and fine over 100 million euros, which is astronomical?
Yeah. It is a big amount. I think what we've seen over the last few years is that GDPR came around, and companies were and are very focused on doing the right thing in terms of protecting the personal data. But what has maybe been left out has been the tracking, which with the software solutions out there are becoming more and more, I think, intrusive in some ways. And especially the third-party cookies are starting to really tailor towards the targeted audience. We're able to do so much. And I think that development over time has made the regulators more aware of third-party cookies and tracking is as, or potentially as intrusive as what we saw in the pre-GDPR days. And that's why they've started to take a focus. What we're also seeing is that there is a big movement with the regulators right now. We've had the e-privacy directive for many years. We've all seen these really annoying cookie pop-ups. But the thing is, nobody has really taken it seriously. Nobody's really done anything to capture the consents. And what happened in 2019 is that we started seeing actual enforcement. And I think what all started it was a verdict that we had coming out related to the Planet 49 decision. I don't know how many of you guys know it, but the Planet 49 decision was the first real firm stand we saw from the EU court about how to capture the right consent. And that, given the fact that they then now said, okay, we cannot accept we use cookie pop-ups, like, those little banners on the website, right? They said these are not permissible. They also said that you can't have these walls that are blocking the access to the website unless you give consent.
Yeah.
And that ruling required all the regulators around Europe to now actually start doing something. And if we take the Danish ones, they ended up having to change their guidelines and their normal decision-making processes due to that ruling.
Yeah.
And that also means that a lot of the regulators around Europe have issued guidelines now.
Yeah, yeah.
Way more explicit information about what it is you need to do, and now also starting to enforce it. As a good example, CNIL, the French Data Protection Agency, in October came out with guidelines about how to capture right consents for cookies in France.
Yeah.
They've given companies a 6 months notice period, and by March 31st, they'll start enforcing it. And talking a little bit about CNIL, that is not the agency to mess around with.
Definitely not. They do what they say they're going to do.
Exactly, and also the authority behind the Google and Amazon fines.
So if I could just jump in there, because we'll get onto those fines. Absolutely, this is fascinating because I'd not really thought before of Planet 49 as the cookies version of Schrems 2, but in a way, it's like it is the cookie version of Schrems 2, and it kicked off all of that. I mean, I remember the decision coming out, and you can disagree with some guidelines potentially, and there's different guidelines across Europe. We'll come onto that a little bit, but you can't disagree with the CJEU decision, and it was basically Schrems for cookies, wasn't it? That's a really good way. Yeah. Sorry, so we're just talking. So the Google and Amazon fine. Sorry, I interrupted you just as about to go into these. So what were the sort of surprise? There was very surprising, really, the activities they were doing, and because very simple errors. Let's call it that. So what would those simple errors be that the people listening could go, well, that 100 million fine doesn't sound 135 million fine doesn't sound relevant to me, but it's really, really relevant. We were talking just before we went live about the sort of notices we see around the place. Why is it so relevant to pretty well everyone using cookies?
Well, I would actually say that there are some fundamental things you just need to get right.
Yeah.
And they aren't that difficult to do, but you might need software for it. But those are, you need to get consent for non-necessary cookies. Yeah. So the little banner at the bottom of the page saying, our website uses cookies, okay, and that's the only setting option you have, well, that's non-permissible. That's just a no-go. The other part is you need to then have categories. So cookies aren't just cookies. That would be way too simple, right? The way that you're doing it is that you have buckets, and the classic buckets being necessary cookies. That means the cookies you need to have on your website to make it run. Though they don't require consent, but they do require you to give information to your audience about the usage. Then you have the analytical cookies, you have the preference cookies, and you have the marketing cookies. Those are the other three standard buckets you see the majority of companies using. Analytical cookies being you know how many people are visiting your website. You know which pages that they're actually reading. You know for how long they're going on each of your sub pages. You might know the referrer traffic, meaning where are they coming from when they land on your website. Then you have the marketing cookies. Those are when you're doing your LinkedIn advertisements. And you'll be able to track whether or not people are actually clicking on the ads and so forth. And then you have the preference cookies. The preference cookies are, for example, your language settings. It can be that you're looking at a YouTube video and you're pausing it. It will know which time zone you're in so that it's shown in the right time format. Those are kind of like your preferences. They require consent. Yeah. So what you need to do is know which cookies you're using on your website and then bucket them into these different types of categories.
Yeah.
And you're not allowed for the non-necessary cookies to start tracking people before they've given consent. And those were one of the fundamental issues that we saw in those cases.
Yeah, absolutely.
Not blocking, not giving people an actual choice. Another really important maybe takeaway is that you need to make sure that people actually have the ability to change their settings.
Yeah. And that's an interesting interaction. Sorry again, with GDPR in terms of, I think people often say, email marketing, that's in GDPR, isn't it? And cookies, that's in GDPR. And actually, both of those rules are in the e-privacy directive, and GDPR provides the definitions of consent and all this sort of stuff. And I think in that bit about withdrawing consent, I think that's become, it was always something that people should be able to do, but with GDPR, it's become really highlighted as a big thing. Sorry, I interrupted you again.
No, it's okay.
It's great stuff. It's great stuff.
Those are kind of like some of the, I think, low-hanging mistakes / errors. What if we're talking, maybe not specifically about this verdict, but if we're talking a little bit about some of the things you also need to remember, is that you need a cookie policy. You need to describe what it is you're doing. And a lot of people out there don't really know that they need a cookie policy or a cookie notice. It depends on like, I think, country to country, what you call it. Another thing is also, what's the difference between a cookie policy and your privacy policy? And can't you just combine the two? And now we're actually touching on muddy waters here, because in some jurisdictions in Europe, you're allowed to actually combine the two. But for example, in other countries in Europe, it is an absolute no-go. You need to have two separate documents because they're regulating two separate areas. And that is also some of the areas where we're seeing that it's getting complicated to be the small business out there and trying to navigate what is it that I need to do and how should I be doing it. Just keeping track of the amount of cookies you're using is difficult enough.
Yes, I think that's right. And I think you've fantastically summarized that. Those lessons learned. It's quite surprising that some of the Amazon and Google pages complained of had no notice, or they had a notice like by using this website. And I still see by using this website, you agree, and I mean, which is just a dinosaur in terms of cookie wording now, and bucketizing them into those different buckets. And I think one of the things I always think about practically is businesses should be more concerned about making sure they don't have anything that they drop before consent that they shouldn't. Basically, I'm less concerned about whether something's functional or performance. There's, some are clearly one or the other, but if there's one you're not too sure about, I wouldn't sort of sweat it so much. But the big thing to sweat about is don't drop anything that needs consent before you get the consent. And with tools out there, there's really no excuse now. The pricing's very, very good. It's very, very reasonable indeed. To just have a nice cookie notice that you can segment everything and collect the consent and show that consent. So, but you just mentioned there about the different implementations, which is one of the things that Amazon said is like, look, everything's different around Europe. It's just too hard and all this sort of stuff. And they said actually also loads of French companies are bad as well. Look at these French, and CNIL said, we don't care about that. We're talking about you, which was a very interesting one. But could you tell us a bit more about some of the variation in the cookies before we come on to the new draft e-privacy regulation, some of the variations you see across Europe, and how much is it really in practice a variation? And then I suppose the follow-on question is, how do you see those differences? Maybe a couple of the big ones, and then how people address that.
Yeah. So if we take maybe just an example, CNIL has gone out and said that they do not accept the cookie banners where you have manage my cookie preferences and you have accept.
Right.
Meaning, and the reason for it, and I actually think it's fairly logical, is that it's super easy to say yes or accept. It is way more complicated to say no thank you or reject, because then you need to click manage my cookie settings, go into the settings, start toggling stuff off, and then say save. But as another way of just saying, showing the opposite size of it, you don't have that stand, for example, in Denmark. The ICO has some fantastic guidelines, but hasn't made it as explicit.
That's what gone in more.
Exactly. They've gone in and said it needs to be balanced, and like you can't really put too much lenience on the accept. But they haven't gone out and say more explicitly, what does that actually mean? And due to the various guidelines and the details of them, the implementations are very different. If you take a perfect example of the Irish commissioner. They have some 2 nice pages of information, but very generic.
Right, right.
Compared to, let's take the French.
Yeah.
Super, like, very outlined, what's required, how should you do it, and what are we going to do about it. Another example is that they've just sent out letters to the top 1,000 websites in France and said, remember, March 31st, we're going to start enforcing it. So we recommend that you take a look at your cookie pop-ups.
That's very interesting.
Very different approach, right?
Yeah.
And therefore, you see variances. In Southern Europe, you're seeing explicit information about a cookie policy and a privacy policy that are not allowed to be combined.
Yeah.
They have to be 2 separate documents.
Yeah. I imagine that one actually, you might say a customer might, an organization might say, well, let's just put them as 2 separate, because there's never, it's unlikely that there's someone going to get annoyed if you have 2 separate ones rather than both in one. So having 2 separate might be a decision customers make they should just do that across the board.
Yeah, and an easier way of doing it, because it will never be a problem. The only thing you always need to do is make sure that they are interlinked, simply due to the fact that, and the reason for it, and maybe that is because of the IP addresses being one of the parameters that are regulated by the GDPR, but actually thereby also regulated by the e-privacy.
Yeah. Which is an interesting one, actually. So let's talk about the e-privacy one, because I knew this would be a great conversation. I'm so happy to have you on. So one of the things with the e-privacy directive is it was implemented differently by everybody. And and I feel that the UK ICO sort of led the way initially with the rule about implied consent. They sort of said, okay, by browsing the website, we'll take that as an act, a positive act, but it's implied from what you're doing. And that sort of spread around Europe. I feel now the UK ICO has lost that lead, and I think CNIL and others are taking the lead much more on this. And I think with us, with Brexit, which we'll talk about I think it's going to be even more so. But with the privacy directive being implemented differently, the new draft e-privacy regulation, long awaited, 14 drafts, 4 years, what have you, has just been adopted. A draft has been adopted by the council, and it now goes into this negotiation and everything. But could you just tell us a little bit, is that a sea change? Is it an evolution, a revolution? Is it on the sort of general rules? What can we say at this point, given that it will change, but we've got a signpost? What's it looking like?
So it's not a revolution, but it is an evolution. Another thing I think is very important to note is more the fact that we're going from having a directive, meaning that each country has implemented its own interpretation of the rules, doing their own enforcement. There's no one-stop shop. With the e-privacy regulation, we'll move away from those national interpretations to a EU interpretation. But that also then means it's going to be very interesting to see how will the UK follow, or will they follow, or will you do your own thing? And what's also very interesting in that regard is what will it mean also for the fines?
Yes.
Because what we've seen up until today is that there is a massive difference in the fines, the aggressiveness, but also the amount of resources that has been put into the areas from the regulator side.
Yeah. And I think that's interesting, because I think I've seen more fines under the e-privacy rules in the UK that are at or near the top 500,000 mark recently, where the regulator's clearly signposting, I think. And actually, that's one of the areas they find more. And I think it's one of the ones that's easy to complain about, as we saw from the stats earlier. And I think that's a signpost from the UK regulator, I think, that here they're desperate to be able to put bigger fines on cookies. So my feeling on Brexit is, and whether we'll follow, is all tied together with adequacy and all this sort of stuff. And I think that we will start to follow, and we're actually, with some of the online legal initiatives the UK government's doing. It's a bit of a mixed bag, but some of them are very much following a more stringent online approach. So I think we may well do. But in terms of the privacy regulation, so that won't apply though, will it, directly into the UK?
No. Given the fact that you have decided to not take part in the EU cooperation. I'm from Denmark, and that's why I'm saying you and we. It's not that I am pro or nothing. It's more just where I'm located.
Yeah.
I think back to the privacy regulation, what's going to be really interesting to see is that it's been a very lobbied act, by the way. You have some tech giants that have a massive interest. I think the whole ad tech industry is under scrutiny and will be even more so with the privacy regulation coming out. But what is really interesting as well is the development we're seeing right now with the Apple and the Facebook and the Googles. And what I'm referring to here is that Apple has taken a very strong stand on their let's say, on their stand towards third-party cookies.
Yeah.
They're gone in with very firm browser settings. You can also see it with the iOS 14 coming out now, also requiring consents in app, and with the Facebooks being very pressured in that regard, because they have been so dependent on their plugins and that data tracking. And Google's with the same approach. But Google's now gone out and said, well, we'll do the same with our Chrome. What is then interesting to see is also that there is a move towards third-party cookies, from third-party cookies towards the first-party cookies. So a lot of the trackers that have been using those third-party cookies are now trying to flip them over to being regarded as first-party cookies. From an e-privacy regulation, what we've seen is that third-party cookies has been almost banned to some extent, if you were to look at it from a practical perspective, whereas first-party cookies has been given a little more leeway.
Yeah.
But with the technology changing, it's going to be interesting to see how that's going to pan out. And that for me is
that's going to
be mindful of.
There's a couple of recitals where they talk about that point that you make very well there, that the third-party cookies may be under threat, let's say that, what have you. But the first-party cookies are going to live on, and so the need to comply, the need to have a cookie notice, the need to have the segmentation about the type of cookies you do remains there, and the need to give notice, but also this sort of, I wouldn't say invisible processing, but the sort of different way of tracking. They're all being played with at the moment, and tracking is tracking, and if the person can be identified, then they need to be told. And that we had a sort of an offline version with the Experian case that came through from the UK ICO here in terms of invisible processing. I think that's something, the UK ICO paused its real-time bidding investigation. It's restarted it again now. So I think this whole it's going to be a very interesting point. So just we're coming up into the last 5 minutes, and could I ask? So obviously, it's a bit of an unfair question. So we've, and again, without taking sides on whether Brexit was the right thing to do or not, it happened. And so from someone in the UK, a company in the UK, if someone's in Europe at the moment in the EEA, their national law applies like the UK national law applies here. If and when the e-privacy regulation does come through, then that makes it so much more simple on in the EEA. Everyone has to follow that set of rules. No doubt there'll be some bedding in, but at least there's a single set of overarching rules. For a UK company in that situation, where we've still got UK PECA here, we're not covered by the e-privacy regulation, what do you think about the law that governs if a UK company is dropping cookies in France, in Denmark, in Spain, or what have you, about which law would apply and how the regulators might see that as well?
Well, I think if we take the standard approach, I think it's going to be more tricky to be a UK entity. Because you would then need to both apply with the UK interpretation, the UK implementation, while also catering to the EU and having to apply with that regulation. But what it then becomes even more tricky is the UK GDPR and then the EU GDPR. because they're, over time, I think, in my personal opinion, are going to go in each of their opposite directions, simply due to the implementation of, let's say, different guidelines and rulings that might come from different authorities. And the ICO has always been very strong in its interpretation. It's been very, I think, pragmatic, but also very enforceful. And they're going to do their own thing, and will be doing their own thing now. And therefore, there will be sliding, I think, rulings that's going to make it even more complex to be in the UK.
Yeah, I think that's right. I was smiling there when you were pausing on how to describe the UK ICO. I remember I was doing a deal once with a French company when I was in a startup, and they said, "Do you mind if we just speak in French for the moment?" And they just started talking about the UK ICO, and their lawyer said, the UK ICO, they're the most, how can I say this? They're the most, and they said lax. And I said, I think we prefer to say commercial, and everybody's a laugh. But I take what you say about the UK ICO for sure. Yeah, it's an interesting one. I think, and also the e-privacy regulation jurisdiction follows GDPR's rules. So it basically, as you say, we've got to comply with, in the UK, with the UK GDPR and UK PECA, and then also the EU GDPR and the EU rules going forward. And the CNIL judgment showed, the combined might of Google and Amazon saying CNIL shouldn't hear that case, and CNIL said, yeah, we definitely are going to take it. I think it shows
and
how much.
And you will see that they would, I would presume that the ICO, the CNILs will still feel that they are empowered to enforce non-compliant behavior by UK entities if they are targeting EU citizens. Meaning, before you only had one regulator, one-stop shop, being UK. Now you would have both the ICO and whatever authority in Europe that feel that they have the empowerment to do the enforcement. And CNIL being very explicit that they feel as soon as somebody in France are somehow impacted, they have jurisdiction.
I think that's it is so just to sort of, we're coming into to close on a positive note for us Brits. So I think in a way, because at the beginning the rules are pretty, on GDPR the rules are identical basically. There's some stuff with sort of like representatives and everything in Article 30 and transfers that need tailoring, but with privacy at the moment the situation is pretty well going to stay the same, and then when the privacy regs come in. But I think in terms of what a business could do, whether it's on the continent or whether it's in the UK, could we just close with a sort of a summary? If we could bring it all together, we talked about some of the learnings from Google, Amazon, some of the direction of travel of the regulation, like a very sort of brief sort of summary of,
So 5 things, right?
Yeah.
Okay. So a little summary. The top 5 things to take away. Look at the cookie pop-up you have on your website. If it says, okay, I use cookies, find a new solution, because you need to give people an actual choice. So there needs to be an acceptance and a reject button. Make sure that you've categorized your cookies into those different buckets. I would recommend using a solution that would scan your website, because it can be really tricky to actually just detect what cookies you're using. Then making sure that you do have a cookie policy where you're describing what it is that you do. And the 5th thing is that, remember, people need to be able to withdraw their consent.
Yeah, absolutely. Fantastic.
So
well, on those very 5 achievable, practical steps everybody can do, there's no excuse not to do those. Thank you very much, Stine. I knew this was going to be great. We could talk forever. We'll hopefully have you back in Privacy Kitchen soon. Thank you very much indeed.
Thank you, Robert.